Hello, everyone. I hope everybody can see my screen. My name is Carrie Tyrrell, and I am presenting today on the role of the prosecutor in the sexual assault response team and generally. As a little bit of background on me, I am currently the Legal Services Director here at the Sexual Assault Legal Institute, which is a part of the Maryland Coalition Against Sexual Assault. I am also a former special victims prosecutor. I worked at the Brooklyn District Attorney's Office for a bit over 4 years, handling special victim felony and misdemeanor cases. So I am happy to answer questions about that as well, although unfortunately I will have to hop off almost right at the end of my portion of this training to go to court on another case. So who are prosecutors? Prosecutors are attorneys who represent the whole state or country, not an individual survivor. This is very important because it means that they don't have confidentiality, the survivor. Many people are used to the idea that whatever they tell an attorney, that attorney has to keep private. That is not so for a prosecutor, for an assistant state's attorney or an assistant United States attorney. They have certain ethical obligations under the United States Constitution and other discovery obligations that require them to turn certain information over to defense and over to the court. As I mentioned a moment ago, in Maryland, the prosecutor's offices are called state's attorney's offices. In other states, they might be called something slightly different, like district attorney's office. And federally, they're called United States attorney's offices. There's one state's attorney in every Maryland jurisdiction, so every county and Baltimore City. That person is elected. We all vote on that person. Well, everyone in the county votes on that person. The lawyers who go to court on behalf of the state are called assistant state's attorneys. And this is important to know because sometimes survivors get upset thinking that they're speaking to someone who is not an attorney when they're speaking to the assistant state's attorney. So it can be very helpful to remind them that this is the attorney who is handling the case. What do those assistant state's attorneys do? They run the criminal cases for the state. Ultimately, they decide if someone gets charged, what crimes get charged, whether to offer a plea bargain or go to trial, and if they are offering a plea bargain, what plea bargain to offer, what evidence to put on at trial, and what sentence they will argue for after conviction. So, who gets charged with a crime? As I mentioned, it's up to the state's attorney's office because they have something called prosecutorial discretion. This is a very famous quote from a United States Supreme Court case. So long as the prosecutor has probable cause to believe that the accused, the defendant, committed an offense defined by statute, the decision whether or not to prosecute and what charges to bring before a grand jury generally rests entirely in the prosecutor's discretion. And when they make these decisions, those decisions are very final. It's very hard to change a prosecutor's mind. And it can be very important for an advocate to be able to explain to a survivor why a case may not have been charged. Obviously, many survivors, if a case is not charged, are going to feel that this occurred because the state's attorney's office did not believe them. That is probably not the case. What may have happened is that the state's attorney's office may just feel that they don't have sufficient evidence. There may be things that the survivor doesn't remember if this is something that happened a long while ago that they would have to have more information about. So setting a survivor up to understand that if a case doesn't move forward, it doesn't mean that the prosecutor's office didn't believe them. So how do assistant state's attorneys and state's attorneys' offices determine what to charge and who to charge? Well, the first thing that they have to do is they have to assess what the crime is, and what the evidence is. As I mentioned before, this can be very challenging in sexual offense cases because generally, by the nature of the case, there aren't witnesses. The evidence may often just be what the survivor says and what the perpetrator may say at trial. They have to consider ethically by law whether there is that probable cause to charge, whether there's sufficient reason to believe that a crime was committed and that the person they're charging is the person who committed the crime. While they don't have to believe there's sufficient evidence to prove the case beyond a reasonable doubt in order to be able to charge a case, most prosecutors will consider that. Why? Because if the case doesn't result in a plea agreement, that is the burden of proof at trial. And many prosecutors don't want to put a survivor through the criminal process if they know that if it came to a trial, it would be very unlikely that the state would be able to prove the case beyond a reasonable doubt. Prosecutors can also take into consideration various objectives in charging someone with a crime. That could be punishment, rehabilitation, or justice for a survivor. So I mentioned before that there's a big difference between probable cause and beyond a reasonable doubt. Probable cause is sufficient reason based on known facts to believe a crime has been committed or that certain property is connected with a crime. And you do also have to have probable cause to believe that the particular person being charged is the person who committed a crime. That won't always be at issue. Many times survivors know the perpetrator and the identity is not a problem. But if it were a stranger, that could be an issue. Probable cause is required to charge someone with a crime. If the case goes to trial, part of the jury instructions in all criminal trials are that jurors are told they can only find the defendant guilty if they are convinced, quote, beyond a reasonable doubt of his or her guilt. This is, again, the burden of proof applied to the state at trial. And if the defendant elects to have a trial to just a judge and not a jury, it is that same burden of proof for the judge. So, what crime to charge? I sometimes liken crimes to almost a terrible form of cookbook where there are certain things that have to have occurred in order for that crime to be made out, almost ingredients of a crime. And so in assessing what crime to charge, the prosecutor has to look at whether the conduct alleged, what the survivor is saying happened, satisfy all the elements of a particular crime or crimes. One act might lead to multiple charges. In other words, anything that could be charged as a rape can also be charged as a sexual offense in the fourth degree, which is an unwanted sexual touching. It could also be charged as an assault in the second degree, which is just an unwanted and offensive touching generally. So when you do see charges listed, perhaps on case search or somewhere of that sort, you will probably see multiple charges listed for one action. Prosecutors also have to consider whether the alleged conduct makes out a felony or a misdemeanor. A misdemeanor is a lower level crime and a felony is a higher level crime. In Maryland, many misdemeanors have statutes of limitations. There are some very important exceptions. However, felonies do not have any statutes of limitations. In other words, felonies can be brought against a perpetrator at any point in time, possibly even decades later. But most misdemeanors have to be charged fairly shortly after the crime occurs. If they're not, unfortunately, the prosecutor cannot later charge them. I think an example helps make this a little bit clearer. So let's look at part of the law on harassment. The law on harassment is actually much longer than this, but I think this is a helpful exercise. So Maryland criminal law section 3-803 says a person may not follow another in or about a public place or maliciously engage in a course of conduct that alarms or seriously annoys the other. One, with the intent to harass, alarm, or annoy the other. 2, after receiving a reasonable warning or request to stop by or on behalf of the other. And 3, without a legal purpose. There's also an important exception. This section does not apply to a peaceable activity intended to express a political view or provide information to others. Obviously, this very specific definition of harassment in the law is quite different than what you and I might mean if we just tell one of our friends, oh my goodness, this person is harassing me. We have sort of a colloquial sense of what harassment is, and it doesn't always match the actual criminal law. So when prosecutors are looking at whether or not they can charge harassment, they have to consider whether there was some type of legal purpose for the conduct. In cases where the defendant and the survivor have children in common, oftentimes the defendant will argue that the 92 phone calls they made were about the children in common. Depending on what kind of custody or final protective order might exist, that might be something that keeps the prosecutor's office from being able to move forward on this crime, because that could arguably be a legal purpose. Another very important question that sometimes stops prosecutors' offices from being able to charge perpetrators with harassment is whether they kept doing these things after being told to stop. There does have to be a reasonable warning or request to stop. And I have seen judges before say, while this person tried to contact you 200 times, based on your testimony, you never told them to stop. Therefore, I can't find that legal harassment has been shown. So this goes back to managing survivors' expectations and making sure that they understand that the fact that a particular crime may not be chargeable does not mean that the prosecutor's office thinks that what the perpetrator did was okay or doesn't believe the survivor. It might just mean that some very technical part of the law didn't occur. So what else do prosecutors consider? We mentioned this earlier. They consider the evidence. They can consider in determining to charge both admissible evidence, evidence that could come in the court case, and inadmissible evidence, because that evidence might ultimately lead to something admissible. Examples of inadmissible evidence in court are hearsay. So when somebody says that someone else told them something, for example, if Jane Doe is testifying and she says, Mary told me that John told her that he was at the party on that night. In court, that wouldn't be something that the judge or the jury could consider. But the prosecutors can consider that because they can go and talk to Mary. Similarly, rumors also can't be brought up in court, but it might be something that a prosecutor could investigate, could try to talk to the people who've been spreading these rumors, for example. Evidence that can be considered both by prosecutors and in court could include photos that might be of injuries, broken property, photos that prove someone was somewhere at a particular time or had maybe some kind of relationship with someone. Written statements that could be by a number of different people. In order to come into court, there are certain requirements to keep that from being hearsay. But if, for example, the defendant wrote some kind of statement apologizing to the victim, that would be admissible potentially in court. Some 911 calls, police testimony about what they observed and what actions they took, also possibly police testimony about any statements made by the defendant. Medical records, other physical evidence that can include all sorts of things. Often it could be broken property, torn clothing, things of that nature. And electronic evidence that can include text messages and voicemails, location services, and also jail calls and mail could be entered into evidence. So we've talked a lot about the burden of proof at trial. Most criminal cases do not wind up going to trial. Instead, most of those cases result in something called a plea bargain. And that is when a defendant pleads guilty to a lesser offense Remember how we talked about how there might be many charges for the same conduct? So they might plead guilty to a lesser of those charges, or even perhaps to the top charge, but to a lesser sentence to avoid the risk of trial. There are some very significant pros for this for survivors. It keeps survivors from having to testify, and testifying can be very challenging, is very invasive. Cross-examination is definitely not therapeutic. And some survivors really don't want to have to go through that process. It also gives them certainty about what the outcome is going to be. Of course, there are also very many cons. The survivor may feel like they don't get their day in court. It is important to remind survivors that while they wouldn't be testifying in front of a jury, depending on the type of plea, they would absolutely have the right to make a victim impact statement. In fact, for any plea, they have the right to make a victim impact statement that the judge can consider in sentencing. They also may not agree with the offer. They may feel that that's not serious enough for what they experienced. As we mentioned before, it is ultimately up to the state's attorney's office to determine what to offer, but survivors do have the right to express their feelings about this offer. Another possibility that occurs sometimes are that charges are dropped. The state enters something called a nolle prosequi. Why does this happen? Sometimes when they review the case in more detail, they realize that there's just not enough evidence to prove beyond a reasonable doubt. Occasionally, new exonerating evidence comes to light. Perhaps the perpetrator was alleged to have done this on a particular day and provide some kind of evidence that he was not in the area, he was out of state or out of country. That doesn't obviously, again, mean that the survivor intentionally lied. It just means that, of course, at that point, the state's attorney's office would have much more difficulties proving that the perpetrator committed that crime in that location and may have to dismiss the case. Another big one is if witnesses are no longer cooperating or available, they can't be located. God forbid somebody's passed away. There is a new law. As of October 1st, 2023, a prosecutor is legally required to explain why they are not bringing charges if a sexual assault survivor requests a meeting for this explanation. That meeting can be by phone, video platform, or in person. So what happens if the case does go to trial? Trials begin with voir dire or jury selection if it is going to be a jury trial. It is up to the perpetrator to determine whether they want a trial to a jury or a trial by judge. Opening statements are made by both the prosecution and defense. After that, it's the prosecution's case. This includes direct and cross-examination of the victim witness and any other witnesses that help support what the victim is saying occurred. Following that, just as a matter of course, a defense attorney is going to make a motion for a judgment of acquittal. They're going to try to argue to the court that whatever was presented was in some way legally insufficient. If you have a survivor who wants to watch the case, it is very important to let them know that this is normal, that this is to be expected, because otherwise survivors can get very concerned when defense starts to do this. After that, the defense can put on a case if they want to. They are obviously not required to do so. The defendant may, but does not have to testify. His silence cannot be held against him, but he also has the right to talk to the judge or the jury if he or she wants to. Additionally, even if the defendant does not testify, the defendant can still call other witnesses. If there's any rebuttal case that the state wants to put on after that, if, for example, the defendant tries to say they were out of state, but it turns out there's employment records that show the defendant was actually in Maryland or something of that sort, then the state gets to put on that case. After that comes closing statements, deliberations, and verdict. Jury instructions are given at the beginning and the end of the trials. So the jurors know what they need to be deliberating on and how they should render a verdict. Verdicts can happen very quickly, or sometimes they can take a while. If the jury cannot agree on a unanimous verdict of either guilty or not guilty, that is called a hung jury. There is an instruction that the judge can give them to really try to work this out and reach a resolution. But if they still cannot, that is a mistrial. And the state has the opportunity to either try the defendant again, reach a plea disposition, or dismiss the charges. So, what happens if the perpetrator is convicted? And this conviction could be by plea or following a trial. The judge decides and delivers the sentence. In Maryland, there are sentencing guidelines for what an appropriate punishment would be based on certain characteristics about the defendant and the crime. However, judges in Maryland do have discretion to go both above and below these guidelines. They're required to put their reason for this on the record. At sentencing, a victim has the statutory right, to address the court and give a victim impact statement. This can be very important and meaningful for victims, especially victims who may not have testified. By law, the court shall take the victim impact statement into consideration in determining the sentence. Advocates can have very important roles in victim impact statements. You all can work together with the victim to think about what they want to say to the judge and how to say it. It's important, of course, that you don't just write the victim impact statement for the victim, but you can certainly help them consider things to include and give them general information about what a victim impact statement is and what the judge is considering. Just as a last summary, prosecutors' interactions with survivors are going to vary a little bit case by case. Sometimes some things will be done directly by the ASA, the Assistant State's Attorney, that prosecutor, the attorney who's trying the case, or they may be done by the victim witness coordinator, who's usually a social worker. This could include an initial interview or a screening interview when they're deciding what to charge. It can also include informing survivors about potential plea bargains, case status. It's important to note that the survivor has the right to request notification of the case status and of plea bargains. They can also prepare a survivor to testify at trial, including preparing them for both direct examination and cross-examination. As a last very important final reminder, prosecutors are not confidential. They have no attorney-client privilege. There are those obligations for them to tell most of what a survivor tells them to defense and to the court, depending on what that information is. So that's why it can be very helpful for a survivor to have an advocate or an attorney. Here's our contact information. As a reminder, Sally, the Sexual Assault Legal Institute, does provide crime victims' rights representation to survivors in these cases, and we're always happy to discuss that with any of you. Thank you so much. And that concludes my portion of the presentation. Does anybody want me to answer the question in the chat just very quickly? It says, can a private party, for example, a victim, file a lawsuit if a state's attorney declines to prosecute? Essentially, what recourse do they have? Civil suit against the accused only, anything against the state? What if more victims result? Prosecutors have absolute prosecutorial discretion. If they choose not to move forward with a criminal case cannot move forward. Survivors can request a meeting to discuss the reasons for this. And if something hasn't been considered, certainly bring that information to the prosecutor's attention. But ultimately, if the state's attorney's office declines to prosecute, that is the end of the criminal case. The survivors could bring potentially civil suits against the perpetrator. There are a variety of other legal options that may be available for survivors as well. They cannot bring any kind of action against the state for failing to prosecute, even if that results in more victims. And I think that was the only question. Did I miss anything before I turn it over to you for real, Grace? I'm sorry, I didn't see that come in.
think that was the only question we have, but if anyone has any other questions, feel free to put those in the chat and we can get them to Carrie.
Thank you all.
Right.
All right, y'all. I am going to start to share my screen and we will go from there. Alrighty, I'm hopeful everyone can see this. I'm hopeful everyone can see this. Please let me know if you can't. My name is Grace Rupp. I am MCASA's Sexual Assault Response Team and Prison Rape Elimination Act Policy Specialist. So today I'm going to talk a little bit about the role of law enforcement and working with victim advocates. Alrighty, so just brief overview. Today we're going to talk a little bit about how law enforcement might receive and respond to a report of sexual violence. We'll review the role of law enforcement in the interview process and how they might collect evidence. And then we'll work on understanding the role of victim advocates during any sort of investigation process. So how does law enforcement receive a report of sexual assault? There are three main ways. The first way is when a survivor reports for a sexual assault forensic exam at a hospital that has a SAFE program. Natalie is going to talk a little bit about what a forensic exam entails, but if a survivor reports to a hospital, hospital staff can call law enforcement to take that report on behalf of a survivor. This requires the explicit consent of a survivor because they also have the option to report anonymously, which I'll go into a little bit later. Survivors might also contact law enforcement directly themselves. So survivors can do that obviously by calling 911, reporting in person, but you'll see survivors report at various times. So you might see them call during an instance of violence. You might see them call in the immediate aftermath, so post-sexual violence, or you might see them report days, weeks, months, years later. And law enforcement is required to take that report and investigate. You might also see law enforcement receive a report of sexual violence during or from a third party. So a witness to the assault, maybe a family, friend, coworker might report an instance of sexual violence. There are limitations to how much law enforcement can investigate this particular type of reporting, but they will receive third-party reports of sexual violence. All right. So what are the responsibilities of law enforcement? What do they have to do? So first, law enforcement's initial response is one that really prioritizes safety, physical, emotional, medical. So initially, they're going to speak to the survivor and determine what happened. They'll assess the need for emergency medical care to take care of someone's physical body and encourage a SAFE, or a sexual assault forensic exam. These exams can be conducted up to 15 days after the assault, and law enforcement can help facilitate the transfer or transportation rather of a survivor to a local SAFE program. Law enforcement is also going to work on collecting initial information to help identify and locate the suspect. And then they'll gather information on the location of the assault and those sort of initial details. So the where, what, when sort of questions. And then law enforcement initially also is working to secure and investigate the crime scene. So you'll see law enforcement start to collect that initial evidence, things like sheets or clothing or condoms, anything that is sort of time limited. They're going to work on securing that crime scene for folks. So within that initial response, right, their first responsibility and primary responsibility is to protect and support the victim, right? So ensuring safety, helping them get connected with advocacy, get connected with resources, address any immediate safety concerns, whether that's for their person or their loved ones. And then also making sure that medical piece is offered to them and facilitated if necessary and relevant or wanted. Also going to work on gathering that preliminary information that I mentioned before, and then working on that evidence collection and protecting the crime scene. So what does an investigation look like for law enforcement? How do they do this? High level, what does this look like? So within the investigation piece, again, law enforcement is working on prioritizing safety for the victim and for loved ones, whether that's family, friends, secondary victims, secondary survivors. So they might, right, be working with you as advocates to help support in that safety piece. Within the investigation, they're also going to work on understanding the relationship with the suspect or perpetrator. So does the survivor know the perpetrator? In what capacity? Also going to work on identifying and locating the suspect. So where are they now? Are they a risk or an ongoing risk to the survivor? Are they a risk to the wider community? So they're continuously making those safety assessments. Additionally, they're working on more of those detailed pieces. So after the preliminary investigation and report, working more specifically on the details of the case, the details of the incident. Also working on identifying where the suspect is now, if a weapon was used, the level of lethality within the assault itself. And then you might also see, depending on where they are in the investigation, law enforcement issuing search and seizure warrants, and then testing for forensic analysis of that sexual assault evidence kit. So what evidence is law enforcement looking for in their investigation? What evidence are they using to help support survivors? So there's a variety of evidence that they might be using or types of evidence, but primary in that is what's called a sexual assault evidence kit. You might also hear it referred to as a SAKE. That's the acronym. And an evidence kit is collected during a forensic exam and then picked up by law enforcement to be tested at a crime lab. In Maryland, SAKEs are held for a minimum of 75 years. Other types of evidence you might see are materials from the scene, so maybe sheets, blankets, pillowcases. You might also see survivors offer their clothing. That can be done at the hospital or given directly to law enforcement, things like undergarments if they were wearing other clothes that the perpetrator might have touched. You'll see law enforcement look for evidence in the form of bodily fluids on the scene, maybe condoms were used. And then law enforcement will also often ask for digital imagery or cell phone communication, communication done on social media platforms, maybe via email. That evidence can be really helpful in starting to build that case for survivors. So important here is another option in reporting that I haven't mentioned. It's called anonymous reporting, or some folks refer to it as Jane Doe or John Doe reporting. So survivors have the option not to report the assault to law enforcement, but they can receive that same evidence collection and the same sexual assault forensic exam. So all of the evidence and all of the medical care would be provided to the survivor free of cost, but law enforcement would not be involved in taking that report. So there's no official police report, and survivors have the option, right, of having that evidence collected from their body and then giving themselves time and space to make a decision or not about involving law enforcement. This is a really important option to know about as an advocate, to be able to communicate to survivors. Again, those kits or that evidence collection would be held for 75 years under Maryland law. But again, if a survivor decides to have an anonymous exam or not report their assault to law enforcement, it's important to be realistic, right? That might change the outcome because law enforcement isn't securing other types of evidence and they're not securing any sort of crime scene. So how can you as advocates support survivors while working with law enforcement? What does our role look like? How do we show up for ourselves and for survivors for when they decide to engage with the criminal justice system? So the role of an advocate, right, during an investigation will be primarily to support the survivor and work on addressing some of those safety needs. So sometimes it can be helpful to be direct, right? Ask the survivor what they need in the moment. Maybe that's a break. Maybe that's a biological need, like water or food or rest. But throughout the interaction, you want to prioritize that safety. So do they have a safe place to stay? Do they feel safe with law enforcement around them? How can we help build in internal and external resources so that they do feel safer? Right? We know the experience of safety is subjective, but how do we help them in building that internal sense of safety? Important as an advocate too, right, is to be able to advise the survivor on the services that are available to them as well as their rights. So as an advocate, it's so important to know what resources are available to survivors in the community, be able to make those referrals, and then facilitate that. So what does that look like in your jurisdiction? Where is the local SAFE program? How are survivors accessing medical care? Being able to advise them around anonymous exams, and really being that wealth of knowledge for them. And then thinking through, right, the investigation process. How can advocates assist in the legal process? So I know y'all have gone through the crisis intervention piece, but really remembering your basics in crisis intervention and coming back to some of those more tangible skills. So on a really basic level, right, we are providing that emotional support, that co-regulation, that grounding presence. We're also advocating for the survivor based on their stated wishes. So really thinking about and asking what the survivor needs and wants in the here and now, and supporting them in facilitating that. We're always prioritizing safety throughout our interactions with survivors. So working through that safety planning that I'm sure Juan Luis talked about, and remembering that safety planning is an ongoing discussion, especially as survivors transition from that initial report through the investigation process. Also helping with those referrals. So referrals for medical, referrals for counseling, legal services, housing. That's really going to be community specific, and it's on the advocate to understand what options and resources are available for survivors. So just some things we want to think about avoiding maybe as an advocate, especially advocates working with survivors who are thinking about or are engaging with law enforcement. We don't want to encourage or discourage survivors from reporting to the police. Our opinion on whether survivors should report is ours, not that of the survivor. And it's not our role to impress or, advocate one way or the other. We're really, our primary focus is the survivor's needs and wants. We really want to remember that not all survivors want to go through with any sort of police process or engage in the criminal justice system, and that's okay. We're going to support them no matter what they decide, whether they change their mind. All of us, survivors included, right, have different understandings of what healing and justice looks like. And for many survivors, that might not include work with law enforcement. I know it can be tempting, but it's not our job as advocates to interview survivors or ask them questions about what happened to them. Really, we want to leave the investigating to law enforcement, and leave that investigation piece and that interview piece for law enforcement. Our primary role there is a support piece. All right. The other thing that can be tempting, regardless of whether a survivor is working with law enforcement or not, we don't want to make promises about what's going to happen. A big part of what happens during sexual violence is that breach of trust that survivors experience, and we want to be, able to fulfill our word, and we can't make promises about what will or won't happen. So saying things like the police will get them, they'll go to jail, we can't guarantee that, so we shouldn't say it. Survivors will often ask, right, like, what's going to happen with my case, or what's going to happen when law enforcement investigates. We don't want to make promises that we can't keep, because if we do, right, that compounding breach of trust is often triggered for survivors. So not all cases get solved. Not all survivors have the same view of justice. The suspect might be arrested but released on bond. Survivors may never move forward in any way beyond getting medical care. And all of those things, right, we can't assume. So really remembering that in our work with law enforcement. So just in summary, we're going to talk more about this tomorrow in the neurobiology, but recognizing that not all survivors respond to sexual violence the same way. And not all survivors will want to report the assault to law enforcement. As advocates, we are there to focus on the survivor's needs and supporting them through the investigation process. Finally, it's not our job to speak on behalf of survivors. We are there to help them identify needs and advocate for those needs with them. We want to know our agency's resources, our capacity, and local resources. And then really important is knowing your own reporting and confidentiality requirements and limitations. And being able to articulate that to a survivor in a way that they understand. Alrighty, y'all. So here's my contact information. I will be here throughout this presentation. If y'all have questions, I'm happy to answer them in the chat. But I'm going to hand it over to Natalie.
Hi, everyone. Just give me one moment while I share my screen. Okay, can you all see this all right? Sounds good. So I'm going to be talking a little bit about the role of the FNE before we move into the final portion of today's presentation, which will be the SART panel. So just for some introduction to who I am, my name's Natalie. I am MCASA's Sexual Assault Response Team and Sexual Assault Forensic Exam Policy Advocate. I'm going to be presenting on the role of the forensic nurse examiner. For today's presentation, I will refer to this role as the FNE. If you have any questions that come up during this presentation, please feel free to drop them in the chat. I believe Grace will be semi-monitoring if anything comes up to FNE work. She's very familiar with it as well. And we will try to answer them. And if I miss your question, I will respond shortly and share my contact information. So to start off, we are going to discuss what a SAFE is. So a SAFE stands for a sexual assault forensic exam, and it's a procedure that provides survivors with important medical care and allows for the collection and preservation of potential evidence from an assault. I find the easiest way to break down and understand a SAFE is to separate it into two parts. So the first being medical attention and the second being evidence collection. So the medical attention portion includes elements such as checking and treating for potential injuries, providing STI prevention, treatment, and/or testing, and pregnancy prevention. So, for example, providing emergency contraception pills like Plan B. The evidence collection portion includes taking photos of injuries, collection of DNA, and collection of clothing items. It is important to note that new laws state that SAFEs conducted up to 15 days after the assault occurred will be reimbursed by state funds. This law doesn't specifically state that only cervical swabs should be collected when a victim presents more than 5 days after an assault. But I just want to highlight that there is that 15-day window, and it varies across states, but in Maryland, they offer those 15 days. Now going into understanding options for survivors. So when understanding the process of receiving a SAFE and reporting sexual assaults, it is important to understand the different options for survivors. So survivors have different choices when choosing to report a sexual assault. They can either do that to the emergency department, to law enforcement, or to a rape crisis center advocate. Survivors reporting to the emergency department may choose not to receive the SAFE and simply just receive medical treatment. If they choose not to receive a SAFE, advocate presence should still be offered. Child protective services and adult protective services are called in cases that involve child sexual abuse or cases that involve vulnerable adults. When I was first kind of trying to develop a better understanding of this, I wanted to understand who is considered to be a vulnerable adult. So vulnerable adults, according to the Maryland's Office of the Attorney General, are people over the age of 18 who lack the physical or mental capacity to provide for their daily needs. So now we're going to talk a little bit about advocacy. Advocates are available to survivors before, during, and after any portion of the sexual assault forensic exam, including in the exam room. So before an exam, advocates can work to address acute concerns identified by the survivor and work through any questions about the exam process. They can explain their role and services, and they will also review potential reporting options. During the exam, advocates can help support the survivor through any and all parts of the exam, including offering grounding strategies, co-regulating, offering encouragement, and empowering the survivor to choose from a menu of exam options. It is important to be aware of what to do if you are in the exam room. So, for example, these may seem like common sense, but don't speak for the survivor and don't touch nursing tools. It's overall just important to understand your physical place and space in the exam room itself. It's also important to be prepared to ask the survivor if they would like for privacy or for you to stay for various parts of the exam. Or when they would like you to stay versus when they would like you to go. So, for example, some survivors want your physical presence during the narrative portion of the exam, but may request privacy during the speculum exam or evidence collection. After the exam, advocates can work on a safety plan for the post-crisis intervention period, which involves connecting survivors with ongoing advocacy or community referrals and addressing ongoing concerns. The SAFE hospital or the hospital with the SAFE program should have a protocol in place in which an advocate is immediately notified when a survivor presents to the emergency department. So advocates can work with FNEs and potentially law enforcement to ensure a timely, survivor-centered, coordinated response to the hospital. An important note is just that a survivor may choose to have an advocate at the hospital even if they choose not to have a SAFE completed. Survivors are not required to have an advocate present, and they may choose not to. In this situation, an advocate can provide contact information or other relevant community referrals for the survivor to reach out to if they want in the future. So providing that option for care later on. Now we're going to discuss a little bit about what occurs during a SAFE. So a SAFE exam or a sexual assault forensic exam includes several important elements, including a detailed interview by an FNE, a body exam, evidence collection, photographs, and documentation of findings. It's important to note that a survivor can choose not to receive any portion of the exam at any time. During the interview, survivors can disclose how they choose or what they choose about the assault. However, an advocate can gently encourage details as it will impact medical prescriptions and evidence collection. Just to provide a time frame, the exam can last between 3 to 6 hours. So now we're going to talk about the external body exam, which will occur during the SAFE. So during the exam, the FNE will look for bruising, wounds, and other injuries that may have occurred during the assault. If any injuries are present, the FNE will then use photos to document the wounded areas. And you can see some examples of that on the slide. There are also cases where injuries are not visible. So that it's super common in strangulation cases. In these instances, an alternate light source may be used to photograph the areas. And so an alternate light source is a technique that can detect bruising or injury that has occurred beneath the skin layer and isn't available or isn't visible to the naked eye. Now we're going to discuss swabbing. So a forensic nurse will use cotton swabs to collect evidence from various parts of the body, including the skin, inside the mouth, and under the fingernails. A genital and anal exam are also completed, in which the forensic nurse conducts both internal and external swabs of the area. The areas that are swabbed are based on the victim's narrative of the assault provided to the FNE. This is why providing details may be especially important, as it can guide evidence collection and increase the likelihood of obtaining DNA. As an advocate, one should never speak for the survivor or force them to provide more details than they are willing. However, supporting them during the process and helping explain why it's important to provide details may also be beneficial. So now we're going to talk a little bit about post-exam. So it's important to mention that safes are offered to survivors free of cost without insurance, because they are government funded. So they're provided by the state or through funding by the state. And the FNE or advocate will inform the survivor about community resources available to them. That can include things like counseling or support groups. And then the survivor will also be offered, as mentioned before, any sort of medication that may be needed. So that can include emergency contraceptives, STI prophylaxis, and HIV prophylaxis free of cost. The exam is free regardless of a survivor's decision to report to law enforcement. There are several things a survivor can do to best preserve evidence before getting a safe. So for example, not changing clothes is important because the survivor's clothes will be collected into evidence during the safe. If a survivor does change clothes, they should bring the clothes with them to the hospital. It's also advised to refrain from using the bathroom, eating, drinking, or brushing teeth. And additionally, refraining from the shower or bath beforehand is also advised in terms of evidence preservation. I do want to just conclude and emphasize on the note that if a survivor has done any of the previously listed activities, it's really important not to discourage them from getting a safe, because the FNE will still attempt to collect evidence. That's why there is that 15-day window. And this is just the final slide with contact information. I will share my information with you all. If you have any specific questions relating to safes, you can always feel free to reach out to our general MCASA info account as well. And those questions will get forwarded to me. So with that, I'm going to stop sharing my screen, and we will move on to the panel portion of today's presentation. So I will give Alyssa a moment to spotlight our panelists. And we'll get started shortly. All right, great. I think we have everyone here. So in this portion of the presentation, we will hear directly from those who have the roles we just discussed. So it'll include a rape crisis center advocate, a law enforcement officer, a forensic nurse examiner, and a prosecutor. These individuals that we have with us today work on different sexual assault response teams throughout the state to help pursue this interdisciplinary and victim-centered response we talked about earlier today. I'm just going to begin with some introductions of our panelists, and then we will get into questions. If you have any questions outside of the ones that we have set for today for the panelists, feel free to drop them in the chat. I'll kind of be semi-monitoring it, so I might miss things and we'll interrupt as needed to kind of address any questions that come up. But if we don't get to any questions dropped in the chat, I will be sure to forward them to the panelists so we can get an answer to your question. All right, so as I said before we begin, I just want to give a brief introduction from each of our panelists. So this panel includes, for the role of the Rape Crisis Center Advocate, we have Shemaine Jones. She has been the sexual assault program manager for the Southern Maryland Center for Family Advocacy since 2018. She has been with the agency for 8 years, first as the district court advocate, which led to her creating the case management program in 2017. She earned a Bachelor of Science degree in Child and Adolescent Studies and a minor in psychology from Bowie State University. And she is now less than 8 months away from earning her Master of Social Work degree with one concentration in trauma and the other concentration in child and family. So thank you so much for being with us today. Next up for the role of the FNE, we have Stacy. So Stacy is the forensic nurse examiner for the University of Maryland Upper Chesapeake Health in Harford County, Maryland. She has been an emergency department nurse since 2008 and a forensic nurse examiner since 2018. She recently transitioned the forensic program to the Aberdeen Medical Center campus, which was recently opened in February 2024. So thank you, Stacy. We're super excited to have you today as well. Next up for the role of the prosecutor from the state's attorney's office, we have Mary Murphy. Mary is the chief of the Special Victims Unit in the Howard County State's Attorney's Office, where she has been a prosecutor for over 33 years. Ms. Murphy has primarily handled child abuse, sex offense, and domestic violence cases in her many years as a prosecutor. She has held leadership positions on the Maryland State Bar Association, including chair of both criminal law and litigation sections. Additionally, she has served on the Maryland Criminal Pattern Jury Instructions Committee. She also served on the board of directors for the Kidney Foundation of Maryland and the Trinity School. So thank you so much, Mary, for being with us today as well. And finally, for the role of the law enforcement officer, we have Jason Baum. So Jason has been a police officer for 30 years. He worked for the city of Pittsburgh Police from 1994 to 2004 and was a team leader and lead sniper for the SWAT team. In 2004, he left the Pittsburgh Police Department and joined the Montgomery County Police Department. And he was promoted to Detective Corporal in 2013 and joined the Special Victims Unit Division in domestic violence in 2015. He was promoted to Detective Sergeant and took over as supervisor of the Special Victims Investigation Division Sexual Assault Unit. So thank you so much, Jason, for being with us today as well. Just to give a rundown of how questions will go, I'm going to start with a general question for each of us. So for organization purposes, I will start with Stacy, I'll go to Mary, and then we'll go to Jason. Shemaine, some of your questions are more specific to advocate work. So when we get to you, I'll give you your question in a way that it's phrased so it's applicable to the work that you do. If you need any clarification or me to repeat any questions, just let me know. I'm happy to. And thank you so much to all of you again for being here today. We appreciate your time. So to start off, the first question is, what is it important for a victim advocate to know about your role in the sexual assault response process? So Stacy, we will start with you.
I don't think we can hear her. I don't know if anyone else is having the problem.
Yeah, I was wondering if that was just me. Okay, sounds good.
Can you hear me now?
Yes.
Okay, sorry, I had to change my microphone here. But I think what patients typically experience with nursing, especially when you're in a hospital setting, is that your nurse forms a relationship with you, they care deeply about you. There's a rapport that's built in healthcare. And this role is a little different in that you don't want to make too much of that relationship with the patient. So we really lean on our advocates to make that relationship because we don't want our exam to be biased. We don't want any part of the evidence collection or the statement or any interview portion of our exam to be biased in any way. So unlike every other aspect of nursing, we try not to make that very close connection with them because I don't want to maybe see something that's not there or, um, I don't know, enhance my exam in any way. So we really lean on the advocate to make that connection with the patient. And we're there to do a job. I collect a statement, I collect evidence, I take photographs, I get you where you need to go. So I think from a nursing perspective, that can be a little different, but it's purposeful to protect ourselves and the patients later in the litigation process.
Thanks, Steve. So Mary, I will hand it over to you.
So our role comes into play typically sorry, can you hear me? Okay. When the case gets charged or is being investigated, depending on the nature of the alleged crime. We too have to maintain some distance in terms of trying to be professional and non-biased and non-judgmental when we're going into the case. So we do rely as well on our advocates, and we have in-house advocates that transition typically with the advocate from the hospital setting. And we rely on the advocates to provide resources so that the victim will stay on board and get help as they go through the process. We typically will meet with the victim after the investigation has been completed to determine whether or not to go forward. And depending on the type of case, sometimes we meet with them before we charge to talk about the facts of the case, and especially if the victim has been reluctant to go forward, either by starting the process as a Jane Doe or coming forward later or having second thoughts about the case. Then we'll meet with them to talk to them about the process because we think it's really important for them to understand the process because they are the ones that would have to testify and go forward. We find that by meeting early with them, then their questions are answered and they are able to proceed on a much higher basis, percentage basis. Our process is that we try to rely on the advocates to provide the support as we're going through the trial prep process and the trial process so that there's one person that they can talk to, not about the facts, but about their feelings, about everything else. And we're the ones that they discuss the facts with and prep the case for trial. We try to explain the process to them and what questions they will be asked. And we also prepare them for questions that the defense might ask of them at trial so that they're not walking into a courtroom not knowing what may be expected of them in terms of the questions, and they're not going to be surprised by a defense attorney by questions that they might ask. We also provide courtroom tours to tell them and show them where they'll sit, make them as comfortable as possible prior to going into the courtroom. Prior to any plea negotiation or discussion, we always try to meet with the victim and to explain to them the guidelines, to explain to them the strengths and the weaknesses of the case, and to get their input about a possible plea. Ultimately, I think it's important that we make it clear to the victims that we have to make the decision in terms of what's an appropriate plea offer, and to explain to them, that we want their input, we want their We want to know what their goals and expectations are and what they would ultimately like to see happen. But we try to also make it clear to them that that burden is not on their shoulders. It's on the state's shoulders, as we are the ones who have to bring the prosecution. So that's sort of, and then we, of course, go into the courtroom and present the evidence and work with the forensic nurse examiners to prep them for trial and to put them on, as well as the investigators in the case. And we go over the evidence with them and put the trial together and all the evidence. So that's sort of a nutshell of what we do.
Thank you so much. Jason, I will hand it over to you. So what is important for a victim advocate to know about your role in the sexual assault response process?
Yes, so we, in most circumstances, have the most contact with the victim throughout the entire process. Depending on the victim's wishes, is kind of determined on how much contact we have with the advocates. There's some victims that, want to deal with us directly, speak with us directly, have all the information and the updates in their case come from us directly to them. And there's some times that they want us to interact with their advocate, who will then provide the information to the victim. So it's kind of determined solely based on the victim's wishes. There are times, obviously, these cases are very traumatic for the victims, and throughout our investigation and while we're collecting information and evidence, we may have to do follow-up interviews and have clarification questions with the victim. Sometimes those questions can be difficult conversations. So when we do have those types of conversations, which could be upsetting with the victim, or if we're unable to, move forward with, an arrest in a case, which does happen, those outcomes can be, very upsetting to the victim. So we make sure throughout the process that they are engaged with their advocates, that they do have advocacy contacts. And if they don't, we make sure that they get those resources. But then once we keep all of our victims updated throughout the entire process. We're open with them in the beginning that obviously we can't make any promises as to the outcome of the investigation, and that sometimes, depending upon the complexity of the case, our investigations could take months, if not longer, depending on what's needed throughout the investigation. But throughout that entire time, we stay in contact with the victims. We make sure that they have constant updates on where we are, where we stand within the investigative process.
Great, thank you so much. So Shemaine, my question for you is, how do you explain your role as an advocate to others in the response process or to the survivor?
So when I explain my role as an advocate, I usually start by letting everyone know that we are specifically here to support the survivor. Whatever the survivor needs, whatever resources they need, whether it's in-person support, whether it's court support, whatever it may be, we're here to support them. We also, more importantly, we educate the survivors and anyone that we come into contact with about our role. And like, again, I said, about supporting the survivor. We do act as a liaison for the survivor between whether it's the sheriff's department, the state's attorney's office, their advocates. But like I said, most importantly, we're here to support the survivor in whatever it is that they're concerned about. Like Jason said, sometimes they want to speak directly with an advocate or have an advocate present when they're meeting with law enforcement or the survivor. So again, whether it's for a protective order, the temporary, the final, if they want us there, we're going to be there to support and offer resources.
Great, thank you so much for sharing. So moving on to our second question, how do you work with victim advocates throughout the sexual assault response process? So this can include before, during, or after an exam or during interviews or any other sort of time you can think of. So Stacy, we will begin with you.
Sure. I think we have maybe the most intimate relationship with the victim advocate as a forensic nurse. We in Harford County at least have a very tight partnership. So I usually engage the advocate before I even go to the hospital and have them come in with me at the same time so that they can start to build that rapport with the patient before we even do the exam. The relationship used to be we would offer an advocate if the patient wanted it or not. We have now moved to a model where we call the advocate every single time. It's not a if, it's a 100% service. So anyway, I would say that I usually give them some kind of report about the patient. I think most of our forensic programs are happening in an emergency department setting. Most of our hospital setting that we're doing this. So for a safety perspective, I do like to make sure that the advocate feels safe. There's a lot going on. Sometimes there's mental health issues with these patients. Sometimes there's substance issues with these patients. Depending on the case, and everyone is different. There's family issues, a lot going on in this period of crisis right here in the beginning. Usually law enforcement's involved, or not at that point, but I would say we get to the hospital at the same time. We kind of figure out what's going on. I usually have the advocate in the room before I even go, start the exam process. We're getting the room ready. I'm kind of starting to get consent and all this information, and the advocate's really building that relationship. So they're giving me crucial information before the exam even starts, like, hey, I think we have some social issue here, or hey, I think we have X, Y, Z. We're really partnering and starting to think about discharge planning, because the exam takes about, an hour, maybe an hour and a half. And then the other 3 or 4 hours after that is all evidence, procurement or whatever, we're packaging things up. That actually takes longer. All the paperwork part, the exam itself doesn't take very long. So we have a very short window of time together. So we're partnering with each other for information sharing. I always use them in lieu of any family member, unless the patient requests it, to do the exam with me. So our advocate is in the room probably 99% of the time now. So they can help witness my exam, so I'm not alone with the patient. And also it limits the patient feeling uncomfortable about saying some really intense things in front of their family. We have a questionnaire that we use. I think maybe 5 or 6 programs use the same questionnaire now, but it is very detailed questions. And so you want somebody in that room that's unbiased, not a family member. You're not saying things that you've had to do, which can be embarrassing sometimes, I think, for patients, or make them feel shameful or things like that. So anyway, it's nice to have a trained individual in there. So we prep before, we do the exam together. And then usually I kind of leave the advocate with the patient after the exam, because I'm over here packing evidence up, and they're really now taking over and doing that discharge plan. Do they have some safe place to go? Are there financial issues? Whatever it is. And they kind of really take over from there. I'll come back in and loop in later for medications, their medical portion of the discharge, but the advocate's really kind of taking over emotionally and post-discharge planning from there. If there's any questions later, I'll usually touch base with the advocate. Hey, is there anything that I missed? Or, we kind of debrief afterwards. Is there anything that you think I could have done better? We help each other professionally develop as well. Hopefully that answers that.
Thank you so much for sharing, Stacey. So Mary, I will pass it over to you.
Sure. In our jurisdiction, a lot of times we don't have the immediate access to the advocate who responds to the hospital. Typically that happens when we're not present and involved in the process. Where we would have the contact typically with the safe advocate would be if there is a passover from the advocacy being performed for the victim to the prosecution process and the investigative process, as it's a decision-making process of going forward. As Jason indicated, sometimes these cases are more complicated and do require a lot more investigation, particularly if we're waiting on a DNA analysis. Our jurisdiction sends it out to outside lab, so it takes typically 2 months to get the results on a rush, which is tough sometimes. But that transition occurs, and our advocate in our office then will set up meetings and assist in getting resources along with the hospital advocate. So it's a transition type of a communication, I think, and that happens between the advocates and our office. And occasionally we'll have the direct contact with the hospital advocate, but then once our advocate gets that baton passed to them, they work very closely with the victim to make sure that the resources are there and to be the conduit for the communication, whether it be for the outcome of the results, those types of things, and waiting for the decision on the prosecution, and then scheduling all of the meetings and giving the updates on the process for the court.
Great. Thank you so much for sharing. So Jason, we'll go to you.
Yeah. So it used to be here that it was law enforcement's responsibility to contact the advocates when we were notified that there was a victim at a hospital getting an exam. Like Stacy was saying, that's changed now. We primarily use Shady Grove Hospital, and the advocates are now called directly by the forensic nurse examiners at Shady Grove. Also, when I get the reports, I assign the cases out to the detectives. My case assignments and the police reports also get sent to our victim advocates, just as a fail safe to make sure that our advocates are notified that we have a victim, and then they get our case assignments and they reach out to make sure that victim was connected with an advocate and they have the resources that they need. We generally don't have, at least in the beginning of the process, a lot of contact with the advocates. There may be times where, our paths cross at the hospital. We'll introduce ourselves, and speak to the advocate, or to see if they have any concerns or anything that we know about before we go in and meet with the victim. We try to keep the advocates out of the investigative process so they don't become witnesses in our case. So we try to do our interviews without having the advocate in the room. But again, it's dependent upon the victim. We do sometimes have cases, it's not very often, but we do sometimes have cases where the victim really wants an advocate in the room with them. And in those cases, it's more important for us, for the victim to feel comfortable and feel open to speaking with us. So in those cases, we'll obviously bring the victim in, but we do try to keep that aspect of it separate, and then just communicate with the advocate and provide them with any information that they may need in order to better support the victim. But again, this is all determined upon the needs of the victim, and that's what's most important for us throughout the whole process.
Thank you so much. So Shemaine, my question for you is, can you tell us a little bit about your work with victims and other professions before, during, or after sexual assault forensic exam?
So we have two ways that we're contacted through our crisis line, but I can't say two ways, but we might, and most often we're contacted through the emergency room, the forensic nurse or whoever's on call that night. They will call our crisis line, give us a little bit of background information, and we'll all meet at the hospital for the exam. Sometimes the exam has to be scheduled for a little bit later in the day if we don't have a nurse on call at the moment or at the hospital to complete the exam. Other times we're contacted directly through law enforcement after they have gotten the case and kind of been made aware of what's going on. I prefer to get the call and go straight to the hospital. I actually responded to 2 this morning, so I am beyond exhausted right now. And they were both pretty, I can't say difficult, but they were both under the influence. So we had to wait a little bit, kind of wait until they sobered up some, and then we could continue the process. So I still have somebody at the hospital right now that we're working with. But for the most part, I halfway forgot the question. I have it here, so let me get back to it. So like I said, that's how we're contacted before. During the exam, we're there. We're there to let them know that we're whatever they need, we're gonna let me go back to my notes. I'm all over the place right now. Um, so Okay, so like I said, as in we're there to advocate for them. We're there to act as a liaison. We're providing accompaniment. Um, we interact with whatever agency we need to. So whether that's the ER staff, if there needs to be sheltered after the incident, after they're done at the hospital, providing transportation. Honestly, it's just whatever they might need. So like case management that day, whether it's case management 2 weeks from that day, accompaniment to social services. We even go, if they need to apply for services anywhere, we're normally there to support them, kind of walk them through the process. Whether it's applying for victims' compensation, you name it. So, sometimes I work with the client from that very day until about 6 months later. So even if the case extends or the trial extends to a year later, which we've had happen before, we're there the entire time. Even with law enforcement, even with the state's attorney's office, here in Southern Maryland, we're kind of just now getting advocates in the state's attorney's office, so we can pass the baton to them. Usually, because we've built such a close relationship with the survivor, they prefer to still have us involved. So it's whatever they need. We're always going to be there. Sometimes I try to say, here, it's okay. You can go ahead and talk to this person. I trust them. But again, if they want us there, and I run this program by myself, so it's usually just me by myself handling every single client that comes through the program. The relationship that we have with law enforcement, I agree with Jason. I prefer to not be in the room for the interviews, but there has been one instance and it was okay, but of course, like I don't want to be called in to testify for anything, So it happened to work out. The case did go to trial. The offender was found guilty, and we kind of just helped her move forward from there. Therapy is always offered free of cost. Obviously, nothing. We don't charge for anything, whether it's a cell phone, you name it, we're going to provide it. Financial support afterwards if they're in a bad situation. So and then out in the community, we're always doing outreach, educating our departments, whether it's individuals from the college, the local colleges, whatever they're, even our local base, we do outreach and prevention there as well. And then we work with those clients who are not active military, but things have happened or they've been assaulted by a military member, which I'm not even going to get into that. That's a whole different situation, but that's the gist of it for me.
Thank you so much for sharing all of that. Okay, so moving on to our next question. What should a victim advocate be able to explain to a survivor about your role in the sexual assault response process? So some things that you could touch on are things like confidentiality, number of times victims are typically interviewed, or things relating to mandated reporting. So Stacey, we'll start with you.
Okay. I think when I get to speak to the patient, I'm going over what the exam entails. They can take that in, but all the other details, because there's so many and they're kind of in crisis mode when we're with them, I think it's hard to take in. So we really rely on our advocates to kind of go over some of the other information, such as this is a confidential service that you will not get a bill for this in the mail. This is a free service. Some of those things come up like, oh, my, especially for minors, are my parents going to get a bill about this? Things that they're worried about reporting because they are worried about the downstream. So it's really important for them to, our advocates, to kind of reiterate some of those things because they're not taking that in when I'm talking to them. They're worried about what's going to happen in this next hour or so in this room. So I think it's really important to explain, the confidentiality, the free service, some of the mandated reporting situation. Obviously, if you're 13 or older, just knowing that information to be able to answer some of those questions. If you're 13 and older, you can come in and have these services confidentially, unless it is a caregiver that is involved, then we do have a duty to report. But other than a caregiver involvement, if I'm 13 and I met a friend and this happened, again, that's their choice whether they want to report or not. So I think just knowing some of those things and being able to answer some of those questions before we get in there is really important. And then I think a lot of patients are anxious about the process itself. So just understanding what is a forensic exam, what is going to happen, and that will come with experience and time. But I think being able to answer some of those questions for patients and just saying, you're going to have this exam, but you're allowed to refuse any portion of the exam. It is your exam to have. So if there's something you don't want to do or aren't comfortable with, you don't have to. This is that, just reiterating with the patient is the driver is really important from my perspective. And I'll let Mary take over from there.
So from my perspective, I guess the advocates would benefit by knowing and hearing what the process is. And typically, in each jurisdiction, they'll handle it differently. So whatever jurisdiction you're in, become familiar with how their process works. Typically in our jurisdiction, we work very closely with the law enforcement, and if it's going to be an on-scene arrest based on the exigency or the facts of the case, then we're going to have a much sooner contact with the victim than we would if it were a case where there was an exam and then there was going to be an extensive examination. But at some point, there will be a review of the case and determination, if it's not an on-scene arrest, whether or not charges would be brought. And regardless of whether we bring charges or not bring charges, we always offer the victim a meeting regarding that decision. What we typically do in our jurisdiction is to bring in the victim after charges have been filed and it goes to the grand jury, and have what's known as a meet and greet meeting, where we simply meet with the victim, have that contact, and make sure that they understand what the process is that will go forward from the charging, the different court dates that they will get notification of, what they'll be needed to come to, what they don't, and not get into the facts of the case the first time that we meet, because we're trying to build that rapport that the advocate probably already has, but that here's yet one more person. And before we do an interview with the victim to go over the facts, typically we've looked at the body-worn camera, the recorded interview that's already occurred. So, we'll have all that information, and they can be assured that we will have reviewed all of that before we meet with them, so that they don't have to, in that first meeting, go into any details other than, to get to know them, to see how they are doing in the process, and to gauge whether they need additional resources, and talk to them about what resources might be needed and what we can do to help. Then, that they will be prepped by the prosecutor to go to court, and that they will be prepared for both the questions that they will be asked and the questions by the state, but also questions that they would be asked by the defense, so that they're not going in cold to the courtroom. And that the prosecutors will describe what the process will be like, how long the process can be anticipated, because that can depend on the type of case that it is, and how many days it would be, and explaining to them that they're not going to be there testifying for 5 days, that their piece is discreet, and that we will include them in decision making, and try to come to a decision what's best for them, number one. And I think that's the most important thing for the advocates to know about our role. Jason?
Yeah, so there's a couple of things, actually. So it's important for the victims to know that just because they file a police report and we begin an investigation doesn't mean that we're then going to force them to continue and move forward with this investigation. A victim at any time can make a decision that they want to stop the investigation or pause the investigation because they're feeling uncomfortable with it. And that's completely okay with us. If they contact us and say, hey, I don't want to go forward, we stop right there. We don't move forward with anything. And then they're free to contact us again at any time when they feel more comfortable or they feel ready to continue the investigation. And then we'll pick up where we left off. There isn't a statute of limitations for our cases. So if they want to stop and they contact us, a year later, 5 years later, we pick up right where we left off and continue on. It's important for the victims to know the reality of these investigations. We get a lot of victims that will contact us, a day after we get the report, 2 days after we get the report, and want updates on their cases, and has an arrest been made yet? And the reality is that, it just in Montgomery County, we get on average 280 cases per year. And I currently have 2 detectives and myself. So the reality is that at any given time, each one of my detectives has, 14, 15 active cases that they're working. So updates, what they would expect, or the time frame that they would expect to have updates, might not match the reality of what we're able to do, because we have so many active cases that we are currently working. So these cases can take, a lengthy amount of time. And then when you're talking about DNA, if we don't make an arrest on a case, and we're waiting for DNA to come back because we need that part of the evidence to give us the probable cause in the case, that could take upwards of 6 to 8 months just because of the backlog right now. We always maintain the victim's anonymity. We do not put our victims' names in any search warrants. We don't put their names in any arrest documents. So none of those things, or that, outside entities can get a hold of, would have the victim's information in it. We simply identify them as victim A. When we speak to the suspects in the case, that's where, unfortunately, the victim's identity can't be kept anonymous, because, we have to establish the fact that the victim and our suspect were in the same place, were engaged in this conduct. So the suspect is going to know what this case is about when we get to that step where we interview them. But again, we take every step that we can to maintain their anonymity from any outside people that are not involved in the investigation. And then throughout the process, of course, if anything comes up where they start to feel unsafe, we ask that they contact 911 first, but they relay all that information to us so that we can take steps to ensure their safety throughout the investigation as well.
Thank you so much. So Shemaine, my question for you is, how do you explain the role of a forensic nurse examiner, law enforcement officer, or prosecutor to a survivor?
So I'll start with the forensic nurse examiner. I usually start by letting them know that this is the person who is going to conduct the exam, and with keeping in mind that this is not someone investigating the case, but that they may have to explain a little bit about what happened to them so that they can properly do the exam. So that means like checking for bruises, taking pictures, things like that. I want them to know that important evidence is collected by the forensic nurse examiner, and that, like I said, they're checking for injuries, offering medications that are important, and that all of the work that they're doing is coming from a trauma-informed place. So they're trauma-informed, and they're considering what has happened to them and how it's a traumatic experience. So again, they're not investigating, but they have to know what happened to you in order to do a proper exam. Of course, I'm missing a couple of things here that I normally say. I can't even think of my normal spiel that I give them. But with law enforcement, I do stress that they're going to have to ask the hard questions and that it may be uncomfortable, which is why I offer them therapy right away. And I try to get them in with the therapist almost immediately, not the next day, but, we'll give them a couple of days to kind of get settled, kind of process some of these things before they have to meet with the detective and, kind of go through this experience all over again. With the state's attorneys, I kind of let them know, or the prosecutor, that yes, you're going to have to kind of talk about this stuff all over again. That they'll have some of the notes from the investigators from law enforcement, but in order to prosecute, they're going to have to ask some of those questions again and kind of prepare you for what's next when it comes to a trial. That's usually the gist of it for me. I kind of usually arrange a meeting with the detective or the advocates from the state's attorney's office to kind of let them do their part, just so they can get familiar with the process and just who they'll be meeting with and who they're going to have supporting them besides myself or my agency.
Great, thank you so much. So our next question is for all of you. So there's no specific advocate question, but from your perspective, what do you think is important for survivors to know about anonymous exams? So Stacey, we'll start with you.
I think a lot of these points were made, but just to know what the information is, I think it's most important in the hospital setting just to give people that option, because I think that there is sometimes a barrier to report. So if that option is on the table, someone might be more eager to have the exam done, or even a portion of the exam, whatever it is, if they know that they have that choice. So I think leading with that is really important in the hospital setting, just as an option if they're not willing to report right away, and just knowing that we can still do everything exactly the same. They can get the full exam, they can get the medicines, they can see an ER doc, they can all the things. It's exactly the same. We just don't attach their name to it until later when they're ready. I think it's also important. A lot of patients think that they can have the exam and it still goes to the crime lab if they don't report, and that's not the case. We're not running those kits. So I think that is probably the number one question I get in the hospital setting is, I'll decide to report whenever the DNA comes back. And that's just really not an option. So that's probably one of the main things they need to know.
Thank you. Mary, we'll hand it to you.
Well, typically I don't ever know or have a communication because at that point we're not involved. But I guess what would be helpful from a prosecution perspective regarding the anonymous exams for advocates to know is that, we don't get involved until somebody decides, as Jason indicated, that they want to go forward. What I think is so important, though, is if there could be the emphasis on the fact that the exam would remain anonymous until they're ready to go forward, because I worry that too many people don't report because they're afraid to have their name out there. And obviously, the best evidence oftentimes comes from the safe exam. And if we miss that opportunity, then the prosecution becomes much less viable. So it's really important for people to understand that, and if the victims are willing to have the anonymous exam done to preserve that evidence, that would be great. But I agree with Stacey in terms of the misunderstanding that their test will be submitted for DNA under anonymous thing. So I think that needs to be part of the conversation as well. Thanks.
Thank you so much. Jason, I'll hand it to you.
Yeah, so for when a victim goes in and has an anonymous exam, obviously that evidence, at least for our jurisdiction, we collect that evidence from the hospital. There's no identifying information on any of the evidence, but we collect it and it's stored in our evidence room until if there becomes a time when the victim decides that they do want to go forward with an investigation, we have that evidence and then we can switch it over to an active investigation. One of the things our department provides, and to the best of my knowledge, we're, if not the only one of the only departments in the nation that do this. We're actually going to be presenting on it at the next AVAWI conference. But our department provides anonymous consultations with detectives for Jane Does at the hospital. So it's an option that's provided to them by the forensic nurse examiner. The victim is asked if they would like to have an anonymous consultation with a detective. And if they choose that option, we're on call 24/7. So whoever the on-call detective is that day, the hospital will then contact the detective and say, we have a victim who would like an anonymous consultation with the police. And so they'll put us on the phone with them, and then that victim can ask us any questions they want about the investigative process, what's involved in it. To answer any of those questions that may help them make a decision on whether or not they do want to go forward with an investigation. So, we've been doing this for about 3 years, and we found there were a lot of times that victims were reporting as Jane Does because of their fear in the investigation, or not knowing exactly what was involved. So by them being able to speak to us directly and ask us whatever questions they might have, helps them to make a more informed decision there at the hospital on whether or not they want to remain a Jane Doe. We don't ask them any questions. We tell them up front, the answers that I'm going to give you are somewhat generic because we don't know anything involved in their case. But we try to answer as best we can any questions that they might have about the entire process.
Thank you so much. Shanae, I'll hand it over to you.
Okay, so basically everything everyone else just said, but we do let them know that it will remain confidential and that it will be stored at our local sheriff's department. That's just where our kids are stored at, and that no one's going to reach out to them. It will have a tracking number, so it will not say their name, first name, last name, initials, nothing. It'll just be a number associated with the kit, and that there is also a tracking system, and that they will be notified before the kit is destroyed. And then also, we want them to know that the advocacy services are still there. So if you still want services, you still want support in any way, we're absolutely there to support you. But other than that, those are the main things and some of the main questions that they have when we speak to someone who has submitted an anonymous kit. I think that's it. Yeah.
Thank you so much. So moving on to our final question. This is once again geared towards all of you. So in your opinion, what do you consider the most beneficial aspect of sexual assault response teams, both for your profession or organization and for survivors? So Stacey, we'll start with you.
I think the response team itself, we meet regularly as a whole team, including MCASA, our local law enforcement, our state's attorney, everybody. We meet probably quarterly, I would say. I'm used to, not as much this year, but I think just having that collaborative effort helps with continuity of care for the patient. So they're, we all know each other. We can kind of communicate with one another. There's continuity along this process with them. And I think us being familiar with one another and having that close relationship, we're very tight knit in Harford County, at least. It's really nice because I can kind of like talk up the next person, like, oh, this detective is awesome. Like, you're gonna, this is going to be great, or the district attorney you're working with is amazing. And, I think being able to talk up that next provider to the patient helps them feel like they have some confidence in what's going to be happening with their case, and what's going on, and makes them have some kind of level of comfort with, the different handoffs that are happening, because it's quite a few between all of us, all of our hands in the pot.
Thank you. Mary, I'll hand it to you.
I would agree. I think the best part about the SART team response is to have that camaraderie and the ability to share information confidentially across the board, and to have the contacts to be able to pick up the phone and say, look, nurse examiner, can you help us out on this? Can you help us interpret this as we're getting ready for trial? Or to the advocate or responding person, we're having difficulty finding resources through our office and our advocates. Can you help us out here with housing resources or therapy resources? So it's really a victim focused group of people who recognize that we depend on one another and we work with one another, and each person has their important piece of the process. And being able to come together in a room, we do it every other month, it is really important to be able to recognize issues, to share information. For instance, some of the things I've learned here today that other jurisdictions are doing, I'll be bringing back to my SART team to say, have we thought about doing it this way? We just want to, it's an opportunity for us to focus on the victims and to provide the best services across the board to victims in a cohesive manner. So it's I think a very helpful way of providing the best we can for our victims. Thank you.
Great, thank you so much. Jason, we'll pass it over to you.
Yeah, so I agree with what everybody's said already, and I won't reiterate everything. The one thing I can say from my perspective, or from the law enforcement perspective, and it's no secret that in the past, law enforcement hasn't done a very good job with working these cases. We've gotten a lot better. We're continuing to get better, but one of the important parts with SART is being able to hear from the other people that we collaborate with on what we can do better, how we can do things better, how we can continue to grow and meet the needs of the victims on the law enforcement side.
Thank you so much. And Shemaine, we'll leave it to you to conclude.
Same. So, I was already working for the agency when I took over the sexual assault services, and we had to create this program from scratch because another agency had it and kind of just didn't do anything with it. So one of the most important things for me was to make sure that all of the agencies that support sexual assault survivors in Southern Maryland are able to communicate with each other. At first, it was all over the place. You didn't know who to contact. You didn't know what to do or which direction to go to. But since having the SART meeting and establishing those connections, we know what to do. There's never a moment where you're like, oh, who do I contact for this? Or what do I do now? We communicate very well together, and, having our SART meeting every other month, it just helps everyone stay on the same page. If there's ever a question, if we're not calling anyone out, but hey, this could have been done differently. We're all there to support each other. So the interagency collaboration has just went from nothing to this beautiful process. And I'm proud to say that because I had a little bit of doubt in the beginning. And anyone from MCASA that has helped us get this program together would understand where we were and how much progress we've made. So just like everyone else, it just feels great to know that you have support in other departments and other areas to help survivors.
Great. Well, thank you all so much for your answers and your expertise and everything like that. We really, really appreciate all of your time. So thank you again so much for being our panelist for today. We appreciate it. And Alyssa, I will turn it over to you for closing remarks.
Great. So I have just posted the anonymous evaluation link into the chat. We greatly appreciate all feedback as we're constantly striving to improve. Additionally, if you're seeking a certificate of attendance or a certificate for CEU credits, you must complete the evaluation form. Upon submitting the evaluation form, you'll see a box at the top of your webpage containing a link. And if you click on that link, you'll be able to access the certificate request form. You can expect to receive your certificate in 3 to 4 weeks by email. If you have any questions, feel free to email me. I will be sending out a follow-up email either later today or tomorrow morning with a copy of today's training video recording, as well as the PowerPoint slides used earlier in the presentation and the evaluation link for today. If you have any questions, feel free to drop that in the chat or you can email me. And thank you again for coming. We hope to see you tomorrow.